Sorry about that, guys. I really had something come up while I was doing that, and let me go ahead and I will fade out the music, and we will get into it right now. Thank you for joining me. On Fridays I always try to wait to put out a video because something always happens, and yeah, so we had something happen today. I'm going to be handling this by myself here. No other people. And this was a motion for preliminary injunction in Illinois brought by McGlynn. I mean, not brought by McGlynn, but it's the GOA case and everything else like that. I'm going to bring up this right here. I'm going to share it over to our screen. I'm just going to blow it up a little bit so I can fill it up. And we're going to be talking about what is going on in this case. This was one of the ones that went up to the circuit court, and the circuit court, the 3-judge panel decided. Did I just lose audio? Are you guys hearing me? Yeah, I guess I'm okay. Decided to go ahead and not go ahead and reverse the preliminary injunction of Judge McGlynn. The plaintiffs in one of the cases, which is the federal firearms licensing of Illinois versus Pritzker, they went back and they went to try to get an injunction on another level, but that didn't happen. So we're going to go ahead and look at this. Okay, so we all know the Second Amendment one that was stayed. So they went back and they were going to try to get it on 14th Amendment concerns for vagueness and everything else. And right here, let's go ahead and read this. After submitting an amended complaint adding the argument that Illinois' registration scheme is unconstitutional under the Second and 14th Amendment, the FFL plaintiffs filed an instant motion for preliminary injunction on November 13th, 2023. The pending motion concerns the emergency rule filed by the Illinois State Police with the Illinois Joint Committee on Administrative Rules that went into effect on September 15th. After the PICA was signed into law in January 2023, the ISP was tasked with implementing a process via which firearms owners could register their specific assault weapons attachment and ammunition designated by PICA. The emergency rule directed those in possession of specifically designated items to upload an endorsement affidavit electronically via their firearms owner identification FOID card account no later than January 1st, 2024. This electronic portal opened up on October 1st, 2023. The criminal penalties associated with knowingly possession of designated assault weapons, ammunition, and attachments will go into effect January 1, 2024. The FFL plaintiffs seek to enjoin the enforcement of the registration requirements implemented by the emergency rules before PICA goes into effect on January 1, 2024. The defendants responded to the motion for preliminary injunction on December 1, 2023, with a motion to dismiss the FFL plaintiffs' two 14th Amendment due process claims and a memorandum in opposition to the motion of preliminary injunction. So basically what happened is they went back and they asked for a preliminary injunction on 14th Amendment claims, and Illinois, they filed another motion to basically dismiss those right out. So that wasn't a good thing, but we knew that they were going to go ahead and file that. So here it talks about standing, whether they like who have standing. Standing basically means that you can bring a suit and you can't. So they always go through that and they always determine standing. This right here, the preliminary injunction is an exercise of a very far-reaching power never to be indulged and except in a case clearly demanding it. This whole paragraph here, actually, the whole entire thing where it describes a preliminary injunction, that's in every case that goes over a preliminary injunction. So basically, that's all copy pasta there. If the threshold requirements are met, the court must balance the equities, weighing the harm to the moving party, and the requested injunction is denied against the harm of the non-moving party to the public. So basically, it has to weigh the balances of the state and the people that actually filed for the motion. Now, if it's unconstitutional law, it will always side with the people. There is no way it will side with the people. I mean, there's no way it will side against the people if it is if the judge determines that the law is unconstitutional. So this is where it outlines everything that happened in the case, and in analyzing a motion to dismiss or failure to state a claim filed pursuant to the federal rule of civil procedures, this court must determine whether or not the complaint contains sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. So basically, that's just saying that, they have to prove that it is plausible on the face. The Court of Appeals for the Seventh Circuit has explained that plausibility is synonymous for probability in this context. Basically, they're trying to say that the probability that something is unlawful that will entitle you to an injunction is there. So it's just describing what is going on with here. So let's go ahead and head down to the analysis. The FFL plaintiffs advanced two primary arguments against the ISP's implementation of the registration requirements and the emergency rules in their motion for a preliminary injunction. An argument that the registration requirements is unconstitutional under the 14th Amendment due process clause, and an argument that it is unconstitutional under the Second Amendment. This case isn't really going to touch the Second Amendment at all, but it's just stating that. The court will discuss each of these arguments in turn. As is the Seventh Circuit's preference, the court will consider the likelihood of success on the merits before considering whether or not the FFL plaintiffs have alleged irreparable harm. Irreparable harm basically means that it is harm that cannot be rectified by monetary means. Yeah, I'm going to get to some of these questions. Rich, you are welcome to come on if you like. As an initial matter, the FFL plaintiffs argue that the injunction must be issued before January 1, 2024 to protect their rights and those of the public. Conversely, the government argues that the FFL plaintiffs are continuing to seek appellate review of their first preliminary injunction motion and that they desire for this court to overrule the Seventh Circuit's decision declining to preliminary enjoin. Once again, this case went up to the Second Circuit on Second Amendment grounds. In the Second Circuit, a 3-judge panel decided, hey, you don't have a right to sue because assault weapons are not protected under the Second Amendment. There is a judge on that panel named Easterbrook who is a hack and very, very anti-gun. So I'll get to the super chats and everything in a minute. I just want to get through this. Then we'll discuss it. And Rich, if you want to come on, you are more than welcome to come on. Okay. The mechanics of Illinois' registration requirements were not implemented until September 15, 2023, more than 2.5 months after oral arguments before the Seventh Circuit on June 29, 2023. Moreover, the ISP submitted a second set of proposed revisions to the JCAR that were reviewed and rejected by JCAR on December 12th, 2023. Therefore, the mechanics of the registration process were not implemented at the time of the first preliminary injunction in this case, and in fact are still in the process of revision. And thus, the FFL plaintiffs are not attempting to circumvent the Seventh Circuit rejection of their first request to injunctive release or to relitigate the positions of the Seventh Circuit just rejected, at least not to the degree that the court will assess their claims there as related to the registration requirements specifically. While the government argued that the lack of mandate from the Seventh Circuit barred consideration of various aspects of this motion, the issuance of the mandate renders these arguments moot. Therefore, the court is within its jurisdiction to address the instant matter, and the court moves to threshold review of the FFL plaintiff claims. So basically, they're saying that they're not going to reject it on face. They're going to actually look at it and he's going to decide from there. Inadequate notice to the people in the community. This is their first 14th Amendment due process clause claim. First, the FFL plaintiffs argue that the emergency rule violates the 14th Amendment's due process clause because the state of Illinois failed to give adequate notice of the registration requirements for weapons, attachments, and ammunition, the knowing possession of which will be subject to criminal sanctions on January 1, 2024. This first argument is directed at the method by which the ISP implemented the PICA mandated registration requirements via the emergency rules at issue in this instant motion. As discussed above, pursuant to the PICA, Illinois residents are directed to register certain firearms, attachments, and ammunition by January 1, 2024, when knowing possession of specific weapons, attachments, and ammunition becomes a felony. PICA directed the ISP to promulgate a process by which Illinois residents could register these items. Illinois law allows for the immediate implementation of rules on an emergency basis without waiting for the completion of a public comment period. What usually happens is that when the new rule comes into effect, there's a public comment period, just like on the federal level. And people can go in there and they can go ahead and register the comments of why they agree or disagree with the new rule, and then they address them all. But they are saying that that is not necessary because it is it was on an emergency basis. And he's saying that Illinois law allows that. The FFL plaintiffs argue that this process runs afoul of the 14th Amendment's due process clause because Illinois did not provide direct notice to either void card holders, specifically to Illinois residents more generally. The FFL plaintiffs argue that the lack of direct notice to void card holders and to Illinois citizens, as a whole, coupled with the short time window for compliance, renders this process constitutionally efficient and insufficient. Basically saying that the 14th Amendment guarantees the due process. This is not due process because you're going to pit it into law right then and there because we're a week away, right? And then you have no time to do it and you can automatically become a felon, which is ridiculous. All right, let's go down here. As they argue, this process is especially concerning because it criminalizes the purchases of specific firearms and firearms accessories that were purchased legally before January 10, 2023, when PICA was signed. The government challenges the FFL plaintiff standing to bring this claim entirely. They specifically argue that plaintiffs do not seek redress for their own injuries. Rather, they seek redress for the injuries they speculate may have been suffered by hypothetical non-parties not before the court. Basically, since the FFL coalition, whatever you want to call it, is suing, they're saying they're trying to sue because on the behalf of their customers who are not a party to this case, and the state is trying to make the claim that they cannot do that. They cannot sue for someone else. Moreover, the government argues that the individual plaintiffs cannot be injured by the endorsement affidavit process because none have alleged that they lawfully owned an assault weapons prior to the act's effective date. And in any event, their amended complaint confirms they all have notice of the process and deadline for registering such weapons. Discussing each of the FFL plaintiffs, the government argues that the gun store plaintiffs and the advocacy plaintiffs, which includes GOA and GOF, are not individuals and cannot be injured, nor can they show specific injuries from lack of notice of the registration requirements. Moreover, the government alleges that the gun store and the advocacy plaintiffs have not seriously attempted to show the type of representational standing that allows an organization to bring claims solely as representatives of its members. This is kind of ridiculous because they are trying to say that, hey, you haven't proved that you actually have members in Illinois. We have members in Illinois. The government tried, they want to get that list, and they're not going to get that list. So they argue that the declaration of Todd Vandermeer, member of the groups, Todd was actually on the Vandermine. He was actually on, we did a fundraiser with them a couple weeks ago. Todd is a great guy. Is insufficient because he states that he has notice of the requirements. The notice claim does not reference the individual plaintiffs in this action at all. The government argues that the FFL plaintiff's burden is at least as great as the burden of resisting a summary judgment motion, meaning that they must set forth by affidavit or other evidence specific facts rather than general factual allegations of injury. The government states that the FFL plaintiffs cannot manufacture standing by either inflicting harm on themselves or by inflicting harm on their members by refusing to submit endorsement affidavits, which is interesting. In their reply, the FFL plaintiffs argue because the registration requirement applies to everyone in current possession of an assault weapon or assault weapon attachment, it necessarily applies to the organizational plaintiffs' members and supporters who are, by definition, gun owners in Illinois. They claim that it is not their responsibility to inform Illinois residents of the registration requirements, and even if it were, the current time frame, especially during the winter holidays, would make such notice impractical. The FFL plaintiffs also emphasizes that the PICA mandated registration requirement applies retroactively to criminalize lawful conduct that occurred before PICA, meaning that the harm is particularly acute here. In their supplemental response, the FFL plaintiffs argue that the matter of associational standing was settled by the Seventh Circuit in Ezell versus City of Chicago. Okay, Rhonda Ezell is going to be on my show in early January, so you got to check that out. All right. And there's Rich. Hi, Rich.
Hey, Crumpy. Yeah, I've been listening. I'm a little behind, but I've been running errands.
Okay. Well, I'm going to keep on reading then. Notably, Ezell states where at least one plaintiff has standing, jurisdiction is secured and the court will adjudicate the case whether the additional plaintiffs have standing or not. Thus, the FFL plaintiffs must only demonstrate that one of the named plaintiffs in their action has standing to bring the suit. So basically, you don't need everyone to come. You just need a single person, and you have standing. As the government states, the notice requirements apply only to individuals who possess FOID card, FOID cards, in order to file electronically an endorsement affidavit. The individual must have. That's a. I'll call them back later. That's another. Must have a FOID card which requires an email, state identification, driver's license, or state identification, and FOID card. I'm gonna skip a bunch of this. So this is just talking about Ezell. It's just going through everything. So I'm gonna skip all this. It's just talking about standing and how they determine standing and everything else by using Ezell. So let me go right here. The government is correct that the absence of clear indication that the advocacy organizations have standing to sue on the behalf of their members, the FFL plaintiffs cannot bring suit on behalf of hypothetical unnamed Illinois citizens who allegedly do not have adequate notice of the registration. This is kind of a really interesting thing, because if they had notice of registration, the state is saying that they wouldn't have standing, but in order to have standing, they would have to be noticed, to have notice of the registration, which is, it's a catch-22.
Yep.
Moreover, the fact that the FOID card holders have not filed endorsement affidavits does not necessarily mean they lack notice of the new requirements. Thus, the FFLA plaintiffs have not sufficiently alleged that they have standing to bring a due process claim for a lack of notice. I'm just going to skip through a bunch of this stuff down to here. That being said, even though the FFL plaintiffs lack standing to sue on the behalf of Illinois citizens who did not receive adequate notice, absent additional factual declaration in case law, the court will address their arguments on the merit in order to adequately develop the record. The Seventh Circuit has stated that the statute or regulation is adequate notice in its of itself, as long as it is clear. That being said, this notice requirement applies to PICA and does not necessarily extend to the emergency rule promulgated on September 15th, 2023. You follow me so far?
It's confusing as mud. I mean,
Yeah, I read through these a lot, so it's kind of one of those things where I read about it so much that it just comes, like, I start understanding legalese, which is probably not a good thing.
probably means you ought to become an attorney, Crump.
No. I'm not going to take the bar. I'm not going back to law school. That people have already tried to talk me into doing that.
Crump, you would be the best attorney on the planet.
No, would not. The key issue is whether I make more than attorneys. The key, just joking. The key issue, whether or not Illinois action offend, I really am joking there, offend due process. Notably, Illinois has taken appropriate action in line with the IAPA. A press release regarding the emergency rule was filed on September 15th, 2023. That is ridiculous. Basically, the saying, hey, there was a press release. How many people read press releases out there besides me?
Nobody.
The ISP filed their proposed rule with the JCAR, which approved it and published it in the Illinois Register, which is kind of like the Federal Register, but state level. Okay, let's see here. The ISP website provided the public with the means to submit comment on the regulation, and 3 public hearings were conducted for the public to attend in November of 2023. In addition to the above, the IAPA contains a catch-all provision which states the agency shall take reasonable and appropriate measures to make emergency rules known to the persons who may be affected by them. And I'm sure they will do just that.
Smoke signals? What are we talking about here?
As previously stated, the individual cannot apply for a FOID card without an electronic FOID account. Even without logging into the FOID card system, a system alert appears with links to a list of those who are required to submit an affidavit, frequently asked questions, FAQs, and the assault weapons identification guide. While the FFL plaintiffs argue that Illinois government should have issued a direct notice by sending emails to each individual FOID card holder, I believe that they should have. The government argues that due process does not require such measures. All right, so they're going to do the absolute effing minimum. You know
So now, if we had any kind of a business and we said, yeah, we wrote it on the chalkboard in our boardroom, that's basically what they're saying is good enough notice.
Yeah. The government insists that the only notification required in line with due process is publication that the Illinois is not required to provide a form of direct notice to citizens of Illinois, regardless of whether it is logistically possible to do so. So they're saying we don't have to do it, so we didn't do it. So we just want to make criminals.
So they're creating magic new law, but that's okay.
Yeah. While not directly in line with the IAPA, the case involves the Federal Administrative Procedures Act, which the Fifth Circuit has used to knock down the bump stock rule, frames and receivers, and pistol braces. The Seventh Circuit stated that notice is adequate if it appraises interested parties of the issue to be addressed in the rulemaking process with sufficient clarity and specificity to allow them to participate in the rulemaking in a meaningful and informed way. Considering all the means that Illinois has employed to confer notice, press release, public hearing, a system alert on the FOID account system. How many people in Illinois actually goes into the FOID account system every month? And more generally, by the fact that that PICA was passed, PICA, the court finds that even if they did have standing, the FFL plaintiffs do not have more than a negligible likelihood of success on the merits of the case, especially since Illinois carried out the process pursuant to the LAPA, which is the IAPA, sorry, the Illinois Administrative Procedure. Critically, the FFL plaintiffs do not challenge the IAPA in the instant motion. They only argue that more direct notice should have been given. The court does not disagree on the onus. The onus is on the individual firearm owner to log into the portal to submit an endorsement affidavit in the first place, and that there is a substantial probability that there exist Illinois citizens who may be unaware of these requirements. However, these facts alone are not sufficient to merit such a far-reaching solution as a preliminary injunction on lack of notice claim, especially since members of the advocacy organizations admit they are aware of the requirements. So basically, that's them knocking it down because they say, hey, whatever. So so right there, they're saying that the lack of notification does not raise to a preliminary injunction level. Now we're almost done here. The second one is vagueness. The plaintiffs next argued that the list of proscribed items in the emergency rule is constitutionally void for vagueness under the 14th Amendment due process clause. The 14th Amendment kind of blocks laws that are vague. Because those can be exploited. The FFL plaintiffs specifically argue that various statutory terms imported from PICA into emergency rules are facially void for facially void for vagueness. The court has entertained and dismissed separate facial challenges to the text of PICA related to its prohibition of certain types of ammunition and weapons. Notably, the text of the emergency rule is imported directly from PICA, a fact that the FFL plaintiffs do not dispute. The FFL plaintiffs argue that various terms to firearms attachments like barrel shrouds, flash suppressors, and pistol grips I just want to stop here and say, do you remember when Tucker asked that one lady in Congress what a barrel shroud was? And she
Oh
was like,
gosh.
it makes it shoot faster. He was like,
Yeah.
no. He's like,
And yeah, just same as a brace makes it fully automatic.
all right. Yeah, it's kind of funny. Itself is sufficiently unclear such that Illinois citizens may reasonably not understand what needs to be registered or how to register certain regulated items and thus may unintentionally violate the law, which would leave at the whim of a relatively unaccountable police, prosecutor, and judges, eroding the people's ability to oversee the creation of laws that they are expected to abide. They claim that these are not so-called margin questions because nearly every definition is vague. You want to start reading?
Sure. The government makes similar arguments to those they raised against the Langley plaintiffs' vagueness arguments in their motion for partial summary judgment, namely that they are the emergency results rules have a substantial understandable core and that all of the arguments about the definitions or different parts are so-called edge questions when the actual definition is at issue is that of an assault weapon. Wow. Let's
Go
see.
ahead.
Moreover, the government argues that the inclusion of a mens rea requirement reduces any potential for vagueness. They also argue that the additional documentation provided by the ISP on their website helps alleviate questions regarding certain attachments, including a fact section with an assault weapon identification guide. In their reply, the FFL plaintiffs argued that the continuous updates ISP has made and continues to make to the fact portion of the website, combined with the filing of the amended emergency rules with JCAR, proves that the definitions of various firearms attachments are vague. The state's own police force has struggled to achieve clarity indeed. As of the filing of this brief, it is still in the process of refining its implementing rules, despite there only being a few weeks left until the deadline to register.
1 week.
Unbelievable. The ISP has also repeatedly amended its FAQ on its website about what is covered. This is because the terms are vague. As discussion in the court's order denying the Langley plaintiff's motion for partial summary judgment, the Supreme Court has made it clear that a facial challenge are disfavored for several reasons. Let's see. First, claims of facial invalidity often rest on speculation. As a consequence, they raise the risk of premature interpretation of statutes on the basis of factually bare bones records. Let's see. Second, they run contrary to the fundamental principle of judicial restraint that courts should neither anticipate a question of constitutional law in advance of the necessity of deciding it, nor formulate a rule of constitutional law broader than is required by the precise facts to which it is applied. Third, facial challenges threaten to short circuit the democratic process by preventing laws embodying the will of the people from being implemented in a manner consistent with the Constitution. We must keep in mind that a ruling of unconstitutionally frustrates the intent of the elected representatives of the people.
Overall.
Where are we?
Overall, exercising judicial restraint and a facial challenge frees the courts not only from unnecessary pronouncement on constitutional issues, but also from prematurely interpreting of statutes in areas where their constitutional application might be cloudy. All right, now just there. Start reading from here.
The FFL plaintiffs more or less recycle the arguments used by the Langley plaintiffs in relation to AR type and AK type weapons to argue that the emergency rules use some terms like barrel shroud, and flash suppressor leave reasonable individuals confused on what is prohibited and what is not. The FFL plaintiffs' arguments here fail for the same reason that the Langley plaintiffs' motion for partial summary judgment was denied. While neither PICA nor the emergency rule provide detailed definitions of specific assault weapon attachments, the ISP website facts section and assault weapon identification guide address the myriad firearms, including with descriptions and images of the weapons in question. See ISP assault weapons webpage. While the FFL plaintiffs argue that the pending updates to the emergency rules and the ISP website evince unconstitutional vagueness in both the PICA and the rules themselves, the ISP's actions can also be interpreted as an attempt to ensure Illinois citizens have as much detailed information as possible so that they can make informed decisions about registration. Ordinarily, a person is conclusively presumed to know the law, which is to say that ignorance of the law that one has violated is not.
Well, sorry. Doing multiple things at one time.
The crumpy multitasking strikes again. Is not a defense to conviction for the violation. And moreover, as the government argued in the motion for partial summary judgment, in the Langley case, the mens rea requirement in the PICA indicates that the government must prove that a defendant acted knowingly beyond a reasonable doubt. Thus, the emergency rules implementation, the PICA registration requirement are not unconstitutionally vague. Rather, they are clear in that they prohibit serious issues with the Second Amendment aside. Additionally, concerns about individual parts are clearly edge questions in the statute focused on defined assault weapons and do not interfere with the statute's core meaning. Moreover, the court has already discussed the vagueness in relation to specific weapons in high-capacity magazines. The emergency rules and PICA more generally may be unconstitutional as determined in this court's review on the merits. However, they are not vague. For this reason, the FFL plaintiffs have not demonstrated that they have a high likelihood of success on the merits and therefore have not met the burden to demonstrate that the emergency rules are facially void. This claim also does not survive the threshold phase. Moreover, based on the decision in the above, the FFL plaintiff's facial vagueness challenge also fails to surmount the government's motion to dismiss pursuant to the Federal Rule of Civil Procedure. The FFL plaintiff's argument in their amended complaint that the statute is facially void for vagueness claims that the PICA defines as an assault weapon any semi-automatic rifle having, among other features, a pistol grip, an additional protruding grip, an adjustable stock, or a flash suppressor. This is a subsection of the PICA definition continues through subsection L before section 1.9A2 defines weapons that are not assault weapons, see PICA 524 blah. This is just language of the PICA itself and does not include the additional context provided by the ISP's fact page.
So it's not in law, they're saying, but since it's on the FAQ.
Which changes every day.
Yeah, which they can just change whenever.
So do you have to screenshot and say, no, I complied with this?
Yeah, but ignorance of the law is not an excuse unless you have qualified
but they're making
immunity.
it so. They're making it an excuse.
Unless,
because
yeah.
how do you How do you comply with these laws? I don't know.
Yeah, keep on going.
The provisions in the PICA and the emergency rules are therefore not facially void for vagueness, they, while they may very well be determined to be unconstitutional in an as applied challenge on the merits and in trial setting after discovery has been completed, the FFL plaintiffs cannot plausibly allege that they are facially void at.
This stage of litigation, this claim does not survive the government's motion to dismiss either.
You read the Second Amendment?
Yeah, well, he goes through it, but then at the end, you're going to see why. We're going to skip that.
Okay.
So just read the conclusion.
Conclusion: for the reasons said above, the FFL plaintiff's motion for preliminary injunction is denied because their notice and vagueness claims under the Due Process Clause of the 14th Amendment do not surmount the threshold phase of the review, and because the court declines to address their Second Amendment claims at this preliminary stage of litigation, the government's motion to dismiss with respect to the notice of vagueness claims is granted. Therefore, the FFL plaintiff's notice and vagueness claims are dismissed without prejudice. It is so ordered. Go F yourself.
Okay, without prejudice means they can refile.
With prejudice would have meant like, hey, no,
it can never come back.
Refile. But how do you, as a judge, write a decision that says, yeah, that might be unconstitutional, but I'll let it go?
Judges are judges, man. They don't want to rock the boat. Let's go ahead and look at some of the comments.
That's crazy.
Start a few. We got a super chat from Robert. Thank you so much, Robert, for that super sticker. I love it. Can't see what it is because I don't have my other screen open, but I love your super sticker. Robert, the support means a lot to me, and because of that, I think I'm going to give you a Wolverines there. Well, except when the whole system is corrupt. That was something that was said. There you go.
Right.
The whole system is corrupt. Kurt 24, member for 4 months.
So did Kurt get all of our packages?
He should have. Kurt, let me know. I'm going to give you a Wolverines too. Dragon Hiller says, Merry Christmas, Johnny, John, and everyone else. There you go. Thank you. Thank you, Dragon Hiller. Merry Christmas to you too.
Merry
and everyone
Christmas,
else.
buddy.
Democrats are power and control hungry, Bearhound said. Absolutely.
Amen. That's it.
Absolutely true, John. Easterbrook is indeed an hack. Grateful he did not go to SCOTUS. That would have been a full auto and a mouth. Yeah, Easterbrook's not a good guy.
Wow. Yeah. Merrick Garland should have been on the Supreme Court also, right?
Yeah. Thank God. Okay, let's go through some of these other ones. No, It's not for me. Living to continue the noble work of our forefathers and vision has brought forth to this day. Reading this and like automatically starring stuff, I can't remember what people are talking about, but that's from the Sentinel. Yeah. It's bad when you're getting better decisions out of the court in California.
Oh, crap.
Coop bringing the fire there.
Coop is right. Holy shit.
Firearms aren't a regulated item in free states. I can sell anything I want to anyone I want. Almost.
Amen, brother.
And that's the way it should be, though.
Yep.
They simply want to call anything they want an assault. They don't like an assault weapon. Well, I think that's what he meant. But yes, you agree. Courts never want to rock the boat. I said that. And one more from Too Many Choices. We need more patriots to stand up and make as applied challenges. It is time. That is a big ask, though, man. That is a big ask.
So Dark is in with the next one. He says the biggest mistake is thinking that people will actually follow these ridiculous law changes.
Then
I
you followed
and how
out.
many people have registered in Illinois? Because the registry window is open, right?
It's just so ridiculous. No one's even really sure.
This is a line in the sand situation for a lot of people, I'm sure. Yep. Yeah.
And we got the judges don't want to rock the boat.
Yeah, the government has made it impossible to uphold the Constitution by forcing everything to be threading elephants through needles. Yep. Right on.
That is 100% correct.
And Warsaw Patriot, this effing blows.
Yep. Then he says, will this be appealed? Is this going to be it would go to a 3-judge panel on the circuit court, which I don't have very much hope for.
Yeah. One car fast civil disobedience got rid of prohibition. Amen, brother. I completely agree with that. And C&T Designs. Read the amicus brief from the gun control groups in Cargill case if you want to get a good headache. Yeah. So some of the legalese will make your head spin.
Yeah, well, some of their arguments make your head spin.
And too many choices. You should never ask someone to do something you're not willing to do yourself. I live by that. Right on, brother.
Yeah, but I don't live in Illinois, so I can't make an applied challenge.
Yeah.
So it would actually have to come from someone else.
Dale Koniha. It's a very low amount, like 3%. And it looks like he's a Masonic Lodge member.
Oh, yeah, you're right. New World Order. Just joking. I'm just joking.
Yeah.
All right, Tech Money. What's up, Tech? How you doing, my friend? Reporting live from the swamp. Yes, I do live in the DMV. I know, but I grew up here. I lived here all my life. I'm not leaving.
This is something I say every time we read one of these Democrat decisions. Is if you read something like the Bruin decision written by Clarence Thomas, it's like a scholarly textbook what you're reading. Whereas when you read something from these Democrats, you're like, yeah, it might be illegal.
Democrat. He actually gave the injunction that got overturned by the circuit court. So I don't think he wants to be overturned, and he knows if he issued an injunction, they were just going to overturn him anyway.
Well, I don't know. I would do it anyhow. I have principles, unlike these judges. When you read a decision from a liberal judge or a liberal activist judge, it reads like, yeah, because I said so, as opposed to scholarly citing precedent and logical reasoning and proper interpretation of the Constitution. It's pretty amazing to me that they say the Second Amendment doesn't include assault weapons, so a registry of assault weapons is okay. I'm like, show me where it says a registry is okay. It says shall not be infringed, and I think that's the end of it.
Exactly.
And yeah, I'm a Second Amendment absolutist, like GOA. That's freaking it. That's the line in the sand. Period. The Second Amendment tells the federal government, "F you, you don't get to touch my rights."
Yeah. I mean, it is. But I think it's going to take time. But this is all going to go down.
Yeah, I mean, we just gotta keep buying Clarence Thomas, Whole Foods salads, and get him an exercise bike. Get him a Peloton for Christmas.
Okay, so it's Kanya.
Kanya, okay. Well, thank you, sir.
Yeah, it's This is exactly what I was saying. He is for gun rights. He's afraid the Seventh Circuit will return him. He is not a liberal judge. And I don't know if you. That's basically what I just said.
Yeah, as far as I'm concerned, yes. So I mean, if you're for gun rights, shove it in their eye, spit in their eye. This
Yeah.
is
So I mean, it's the way you look at it, right? It could be.
I mean, if you're worried about your social standing or your judicial scorecard that you've had, 0 things overturned by a superior court, yeah, then you're the biggest pussy on the planet.
Yeah. I used to be in the FFL, but I gave it up because I didn't want to work within that system anymore.
Right?
You know, I know it's kind of a dark. Your mom's box, exactly. Most important comment of the day. All right. The injunction to block the law was just denied. So, yeah.
So basically, their assault weapon ban is in full force.
Yeah. Well, it will be. Even though the rules aren't even out yet, which is ridiculous.
And you just got to watch the website that changes every day for what the current status is. So whether this piece is bad or not.
Yeah, here you go, Rich.
Everything I've witnessed these days is what my grandparents escaped Hungary and came here. Ouch! I'm second generation USA born. All right, now I got to remember how he said it. Oh, you moved away too quick. Konha, right? Konha.
Yeah.
I will not comply. Amen, brother. I think a lot of this, I think it's our duty to have civil disobedience. That's why I like Lobby Day in Virginia. I mean, if I can, I want to be there, and I'll have a 50 cal with me.
Well, Lobby Day in Virginia is like the week before shot, so I don't think you're gonna make it.
I might make it.
All right.
We might be riding the same airplane as shot, Crumpy.
Okay. Oh man, goodness.
The facts are that they are passing legislation that isn't entirely finished out. It's hilariously disgusting. That's completely correct. So I will not comply. They get these boilerplates from these different activist groups.
Bad. Practical civilian. It is bad.
Yeah, I mean it's amazing to me that these anti-gun groups know nothing about firearms and that they want to regulate them, and then they make the language so vague because they don't understand what they're talking about.
I think you're. I always say never attribute to malice what can be contributed to idiocracy, I guess. But in this case, I don't think. I think they make it vague on purpose because then they can do whatever they want.
I have a lot of trouble with that when you watch these judges go before a Senate hearing for confirmation, and I forget who it was. Senator Kennedy from Louisiana is asking, "Oh, can you tell me what the Section 5 of the Constitution is?" And it's like, how about Section 2, Section 3? And these people, I mean, they have degrees from Harvard and Yale in law. They have no clue what they're talking about. So I think it's both. I think they're both, malice and ignorant.
Are you talking about Article 5?
Yeah, Article 5. Thank you.
Okay, that deals with how to get a new amendment passed. 2/3 of the House, blah, blah, blah.
There's 2 ways to do that.
Yeah, the Constitutional Convention.
Which has never occurred.
Yeah. I'm not for that.
I actually am. We differ on that.
Well, that could be a very
Well, it's a
good
convention of states. It's not a constitutional
a
convention.
convention of states. That could be another.
There could be another S show, but we already got an S show.
No, like another we can cover that under uncensored.
Oh, okay, yeah, another topic to cover. Okay.
Thomas Payne says, "Good afternoon, everyone. Merry Christmas." All right, do you have anything
Merry
else
Christmas,
before
guys.
you go?
I'm good.
Yeah, Obama was a constitutional law scholar, like professor.
Yeah. God bless us all.
Yeah. So how would they know where, like who has an AR unless it's already been registered? Good question.
If you never take it out of your house, nobody knows.
That was the saying. Sorry, never attribute to malice which can be adequately explained by stupidity. But in this case,
Looks
it's malice.
looks like they put both in a blender. Good citation of the quote, but yeah.
So
see.
moving. 2024, may the odds always be in your favor. Thank you, Brandon.
Good post.
Yeah, there was the Massachusetts judge that said ARs are dangerous and unusual, not protected by the Second Amendment. Lots of boating accidents today. You know what? I'm never going to use that line.
Yeah, I'm done with that too.
And yeah, we will see. I honestly, I believe that all these bans are going to be destroyed, but I will buy everyone's AR collections for $100. Take them off your hands so you don't have to worry about it. Just joking, guys. 105. Okay. All right, guys. Rich, you have anything else before we get out of here?
No, I'm good. Merry Christmas, everyone.
Merry Christmas, everyone. I am sure I will speak with you guys, maybe not before Christmas. So if I don't speak to you guys before Christmas, remember,